If you work in the creative industry, then episode 97 of IP series with Rita is for you. And with that, I welcome you to today's episode. My name is Rita Anrichinda. I am an intellectual property lawyer and information technology lawyer based in Rivers State, and an arbitrator as well, and a Rotarian. Don't know if that's relevant, but yeah, I just have to put it out there. Well, welcome to my podcast where I talk about recent cases and developments on copyright, trademark, patent, industrial design, trade secrets, plant variety, and geographical indication. Now, if you haven't listened to the previous episode where I talked about the Domitila case, sister, listen to it, or listen to all the 96 episodes. It will make my day. Share, like, subscribe as well. For my tiny listeners, you guys already know the drill. You are the best. Now let's dig into our review of the Copyright Act 2022. So last month, President Muhammad Buhari had assented to the copyright bill to repeal the Copyright Act of 2004, and this has been a long time coming. Now, we will recall that last year there was a public hearing that was held. It was a hybrid public hearing, so I was able to participate virtually all the way from Port Harcourt, but those who were physically present in Abuja made some contributions and all of that. Now, this law has finally been passed, and we have the Copyright Act 2022. So, and what I'm going to say is, this act was well thought out. I'm going to commend everyone who participated in drafting this law. It tackles issues that creatives faced in Nigeria. We're not going to talk about international issues as to AI generative works. This will emanate as a result of any other new emerging frontier or tech, such as the NFTs, the metaverse. These are not our immediate problem at the moment. We have bigger issues in terms of ease of reproduction, someone altering a copyrighted work, distribution, communicating to the public, unauthorized use. So I'm just going to go through. I will first of all highlight the new provisions, and then I'll give like a general review of the act. They're about so it's divided into 12 parts and 109 sections, while the old act was divided into 4 parts, 41 sections, and 5 schedules. So what thing again that I noticed about this was they kind of merged the previous. So we have the Copyright Act and then other regulations that help sort out some issues, such as levy on materials, copyright levy materials, dispute resolution mechanism, collective management organization regulations, those things. So it was just kind of incorporated in certain part, but from publications and few events I've attended that the NCC was featured in, they've said they're going to come up with more regulations to back this act up. So yeah, let's not give so much thought to the fact that this law or this act did not include emerging techs and new frontiers. But then we have, with good strategy as a copyright practitioner or an intellectual property practitioner based in Nigeria, I'm sure you'll be able to come up with innovative ways to help your clients when they start to experience all of these things. Now, the commencement date for this act is 17th March 2023. Now, if you look at the introductory part of the act, it says an act to repeal the Copyright Act Cap C 28 Laws of the Federation of Nigeria 2004 and enacts the Copyright Act 2022 to provide for the regulations, protection, and administration of copyright and for related matters such as performance rights, folklores, etc. Now, Section 1 states that the objective of this act is to, one, enhance the capacity of the Nigerian Copyright Commission, which I would want to, like, again, I want to commend the drafters. I mean, the role of the Copyright Commission was expanded. Like, you're definitely going to see, I think if you do like a keyword search, let's do that together. So keyword search of commission will give you about, oof, sorry guys, I don't know if you heard that in the background, but it will give you about 192. That's the result that comes up. So you get a set, when you put in the search was commission, you get 192 hits. So that tells you that the entity is willing to go the extra mile to make sure that they not just regulate or administer or enforce compliance of this act, but they are ready to engage the creative sector. So if you work in the creative sector, please, for every time you see any publication that the Nigerian Corporate Artists organizing an event, please make sure you attend it. I'm aware there's one coming up next month. Let me get that for you. It's a collaboration between the Nigerian Copyright Commission and the World Intellectual Property Organization. So it's a workshop on collective management operations and licensing organized by Nigerian Copyright Commission in cooperation with the World Intellectual Property Organization for officials of collective management organizations, copyright authors and owners, officials of government agency in the creative sector, and IP lawyers. Date is May 3rd to the 4th, so it's a 2-day event. I have registered because I want to get all the deets about this law. I don't want anyone to say, oh, Anwar is not prepared. Like, I'm really impressed. I think I'm going to keep saying that. But then again, there's another document that was published last year titled Licensing and Operation Manuals for Collective Management Organizations. That was a research work by the Nigerian Copyright Commission, the World Intellectual Property Organization, WIPO, MCSM, AVRS, and REPRON, which are like the three major strong collective management bodies right now in Nigeria. So we don't longer use collecting society. So if I've done any interview, I think I did one last week and I kept referencing collecting society instead of CMOs. But yeah, that's one of the objectives of this act, and it also gives the authors the right to enjoy rewards and recognition for their intellectual property. So no more and then there's no room for anyone that's been taking advantage of anyone anymore, because now as an author you have the right to be recognized and acknowledged as the creator and owner of the work. So the next one will be Nigerian compliance to international copyright treaties and conventions, such as the Marrakesh Treaty, which promotes awareness in accessible formats for the blind, visually impaired, and print disabled persons, in Nigeria. You can find that under section 26. I'm going to talk about that as well. And also, I was very impressed with the fact that some provisions of the copyright treaties were introduced into the act. Like, I mean, you guys just said, see, Nigeria has to do better. I mean, we're exporting our copyrighted works such as music, our films, our fashion. Let's help these guys do a lot better. And also introducing these special provisions for those who are disabled is also commendable as well. And then finally, provision for appropriate limitations and exceptions to guarantee access to creative work. This is where compulsory licenses comes into play. So I'm going to talk about all of those things. Section 2 now goes for that. Section 2 sub 1 now goes for that to introduce the list of eligible works to enjoy copyright protection, and they include literary works such as novels, stories, poetical works, plays, stage directions, audiovisual works, sceneries, and broadcasting scripts, choreographic works, computer programs, textbooks, treatises, histories, biographies, essays, articles, encyclopedias, dictionaries, directories, anthologies, letters, reports, memoranda, lectures. I'm a lecturer now, so I'm really happy. Uh, Addresses, sermons for those in church. I think last year or last 2 years was this, conversation as to copyright protection for gospel songs. Not much have been said about sermons, but I think this addresses that now. The sermon is copyrighted, but I think that was like a given already. It's a written work. So then you have lectures, addresses. Oh, I talked about that. Sorry, guys. Law reports, excluding decisions of court. So my legal bloggers, you guys should take note of that. Written tables and compilation, including tables or compilation of data stored or embodied in a computer or any medium. Yeah, that's for literary works. Let's look at musical works, which will include musical compositions irrespective of musical quality. So we already know that musical works, there are two types. You have the music composition, that's which I already stated there, and sound recording, which means the fixation of a sequence of sounds capable of being perceived orally and of being reproduced, but does not include a soundtrack accompanying or incorporated in an audio visual work. So yeah, then the next eligible work is, hold on, I just want to get them in the right order. Artistic works. Yeah, so let's look at the definition of artistic works. I'm taking my time to go through this so we don't have issues as to what qualifies as that. So when I just mention it in the course of the conversation, you know what I'm actually referring to. So artistic work will include paintings, drawing, etchings, lithographs, woodcuts, engravings, prints, maps, plans, diagrams, work of sculpture, photographs not comprised in an audiovisual work, works of architecture in the form of building models, and works of artistic craftsmanship, including pictorial woven tissues and articles of applied handcraft. Next eligible work is audiovisual works, which used to be cinematograph works. Yeah. Hold on. Audiovisual works would mean aggregate of a series of related visual images with or without sound, which is capable of being shown as a moving picture by means of a mechanical, electronic, or other device, and irrespective of the nature of the materials on which the visual images and sound are carried and included, and includes the soundtrack but does not include a broadcast. So again, kudos to the drafters. Like it's not easy thinking of all these things. I already defined what sound recording is, and then I'm going to talk about the final type or eligible work for copyright protection, which is broadcast. So you see that in the law, broadcast comes up, I think, a lot, not so much, or not as visible as CMOs, but broadcast will mean the transmission by wireless means of sound or images or both in such a manner as to such images or sound to be received by the public. Then it defines broadcasting organizations to mean any authority established under any law in Nigeria or elsewhere providing broadcasting services for public reception. So if you work in the broadcasting industry, this is for you. Then let's look at the definition of choreographic work. I mean, we've had instances where someone is trying to lay claim to a dance because it's gone viral. So under the law, choreograph works would mean a composition of movement for dancing or any other patterned succession of gestures mostly created to accompany music. So don't say we do not have laws. We have the laws right now. We have the laws that takes care of all of these things. So now what is the criteria for eligibility? And this can be found under subsection 2 of section 2. So section 2 subsection 2. I hope that makes sense anyway. But yeah, so one is that effort must have been put in making the work. There must be elements of originality. It must be in a fixed medium of expression presently or to be developed later, to be reproduced or communicated either directly with the aid of any machine or device. And I don't think, okay, there was no definition for what a machine or device would be, because in some part of the sections device was mentioned, but I think maybe the regulation will clearly define that for us. But if it doesn't, I think that we can use that or interpret it to mean technologies being developed presently to aid the use of copyrighted work, whether authorized or unauthorized. Then it doesn't also matter the quality of the work, so long as it meets this basic requirement. It doesn't matter the quality of the work or the purpose for which the work was created. So then subsection 4 talks, oh, I already talked about that. Subsection 4 says a work shall not be eligible for copyright by reason only that the making of the work or the doing of the act in relation to the work involves an infringement of copyright in some other work. What that means is this: the fact that you infringed on someone's work does not take away the fact that it has the basic elements or criteria of being in a fixed format, original, and effort has been put, in expressing that work, and not minding the quality as well. Then copyright in the compilation shall not confer any exclusive right in the pre-existing material of the data. And finally, an artistic work shall not be eligible for copyright if at the time the work was made, it was intended by the author to be used as an industrial design as defined under the pattern design. So if for instance you have created this work, and so the former act has stated if it's meant for industrial reproduction or multiplication and all of those things, then it's not meant to be copyrighted. So design right already protects visual appearances of a design that is new, whereas for copyright we'll be talking about originality, which I think new will also fall under that. But then if that work was created to be a design work, then it will not enjoy copyright protection. That is my interpretation of that particular section. So I'm going to take us to the next one. So remember how I talked about the expansion of the role of the Copyright Commission. Now let's look at I already talked about section 1 sub 1, which one of the major aims of NCC is that they have the power to regulate, administrate, and enforce the compliance of this act. Then the commission can also intervene in a situation where there is more than one collective management organization to receive royalties on behalf of performers, and then they can also decide which of them should receive the royalties, especially when it has to do with remuneration for broadcasting of sound recording. So you can find it under section 15 sub 5. Then the commission can also issue certificate as proof where the country is a party to, say, one of the copyright treaties that Nigeria is signatory to or is a member state of. That is on under section 8 sub 2. Under section 27 sub 5, they have the power to make regulations, like the special exception for the sound recording of a musical work. Then section 31 sub 4 mandates that the commission has the right to grant applications for non-exclusive license to produce and publish the translation of any work in the language mentioned in the application. So you know that copyrighted works such as literary, musical works, and audiovisual works can be translated or adapted. So one of the rights that they have to give, or where someone applies for it, is to grant them a non-exclusive license. So licensing is you giving someone authorization or consent or permission to use your work within a certain period of time in line with the terms and conditions of that licensing arrangement. Now, if you're going to do that, it has to be for the purpose of you teaching, scholarship, or research. Now, there's going to be a calculated rate for the use of the work in line with the standard for licenses, and I'll refer you guys to the licensing policy for translation and reproduction of International Financial Reporting Standard for adaptation, which the commission can reproduce by reaching out to either the IFRS to get the requirement for Nigeria to adopt this. But I do not know presently if the Nigerian Copyright Commission already has a guideline or a royalty rates that can be used for this purpose. So maybe I also need to look out for the regulations as well. They have the right to authorize a compulsory license for public interest, where in a situation where you have made reasonable efforts to reach out to the owner of the work to get consent, permission, authorization for commercial use. But in that instance now, they can waive that for you, especially if it's like a national emergency. So that wasn't defined, but then you cannot on your own say, oh, this is a national emergency, then I just want to get a compulsory license for this, blah 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 blah. So the commission is going to take care of all of that. They will help you in determining whether your use is for a national emergency. So I'm going to check this in because I attended a Twitter space where Mr. Akpan had made reference to an example that a national emergency, because I had to ask the question, a national emergency would be in a situation where so for instance during the pandemic, some private schools still continue using copyright ever, but those in the public school could not access all of this. So that could be a national emergency where it's for the public interest, for students, so that they are able to learn, they have access to knowledge and materials and all of those things. And I think, again, this is commendable for the commission and the drafters who thought about this, because normally when I hear compulsory licensing, I'm only thinking of patents. I've never seen a compulsory license provision for other types of intellectual property mechanism other than patent, which is usually used for emergency situations. So in the event of a pandemic, you need to get access to certain informations of the drug that will be used to for vaccination and all of that. So it's that detailed. Then section 49 talks about the powers of the Commission on Anti-Piracy, which was retained but reintroduced under subsection 5, where an offender who claims to not know that they had in their possession an anti-piracy device can prove to the satisfaction of the court and will be liable to a fine of at least 100,000 or imprisonment for a term of 5 years or both. I mean, they try. The minimum sanctions that I've come across in course of reading this act is, impressive. I mean, we've transitioned from the previous act to this. It's something. Is this something? Then importation of prohibited goods or infringing copyright works. This is a collaborative effort between the NCC and the customs. Yes, and the customs. So what the law now provides is that once the owner of the copyrighted work has notified the Director General of NCC, he will then notify the Comptroller General of Customs or any other officer in charge of that relevant border with the relevant information to identify the work, intercept it and impound it, and then permit the DG of the NCC or any person that the DG has appointed to act on his behalf to inspect the impounded work and then take custody of the work, which will be kept for at least 10 working days and maybe subject to extension. You can extend it for another 10 working days. Then subsection 5 of 53, which talks about importation of prohibited goods or copyrighted works, infringing copyrighted works, says that the person who imported it will be notified by the Comptroller General that this action can be taken, that actions can be taken. Then the notice that will be issued will not exceed 5 years. I think it's a bit too much. I mean, 5 years for notice, say we seize your thing. I don't know, guys. I think maybe they should have said at least 12 months as 1 year. But then it shall not be extended beyond that period for which the copyright subsists for. So I'm not going to. I don't know why I like saying I'm aware. So I know I've seen publications by the EU and the UK and the US anti-counterfeiting group where they work hard to make sure that infringing IPs. When this is I was talking about copyright now, do not get into the country because someone has bypassed certain routes just to get this product into the country. Section 55 talks about takedown notice, which is like, when I saw that, I was like, oh, IP in the digital age. Yes, Nigeria, thank you for that. Now, in the event of a takedown notice for an infringing content under section 55, the commission under subs 4 can review the matter just to appease the copyright owner, especially when they're not happy with the decision or determination of the service provider. Then, in the event of a serial offender, someone that likes to, put up infringing content, reproduce or publish or exploit any of the commercial bundle of exclusive rights according to a copyright owner, the Copyright Commission is the next line of appeal where the service provider can reach out to NCC to resolve the complaint within 10 days. So this is a form of alternative dispute resolution mechanism that the commission is going to be participating in, and I love it for them, guys. I really do. Then section 78 sub 1 lists out the roles, the powers of the commission to include: 1, they shall be responsible for all matters relating to copyright, obviously, I mean, including administration, regulation, and enforcement, which is in line with section 1, sub 1 as well. They have the right to monitor and advise governments on Nigerian position in relation to bilateral and multilateral agreements between Nigeria and other countries. Love it. investigate and redress cases of infringement of copyright and settlement, and settle disputes of copyright where those disputes have not been specifically reserved for settlement under this dispute. More responsibility, please, guys. If you work with NCC, edge up, please put me in your panel of neutrals. I also have qualifications and specialty as a dispute resolution practitioner. But yeah, let's build our dispute resolution, IP dispute resolution skills more. So I'm volunteering my services. So put in a good word for me, guys. Enlighten and inform the public on matters relating to copyright. And I'm sure they're going. I mean, with the level of engagement I've seen within the last few weeks, I was going to say days, but NCC is going to do a lot more PR in terms of engaging stakeholders. I mean, it's going to be taxing. So if you need help as well, Henry is here. I would gladly love to collaborate with the NCC to enlighten the public on matters relating to copyrights, create and maintain a register and database relating to copyright work, which is nice. Also provide access to document and information relating to any copyright kept or maintained by the commission. So we used to do like a depository form of IP registration, but now with the law, so there's a provision that says you may, not shall now. So why you may see that is like optional. It's not optional per se. So in case you're thinking, oh, they did not make it compulsory, please shall go and still register or deposit your copyrighted work, because the commission will also give you a CTC in the event of a dispute, just to give you an edge to show proof that you are actually the copyright owner. They also provide, okay, I mentioned that they are also responsible for any other matter that relates to copyright. They can exercise any other function or duty that may be necessary. They have the powers to prosecute, to conduct or defend before a court any charge, information, or complaint, or any proceeding arising under this act. Levy such charges or fees as may be reasonable for services and facilities provided by the commission. Regulate and implement measures to promote protection of copyright. Regulate the conduct of collective management of rights. Love it. I think that was already in the previous act as well, but this is for more emphasis. Exercise such other powers as are incidental to or object. Then, in the course of exercising their powers of enforcement and compliance, they shall have the power to demand for evidence of compliance from a person, from persons, public or private institutions and organizations. So, if you have NTC coming to demand proof that you actually have authorization, please make sure you comply. Don't stress, my guys. Don't stress these people that are trying to make the lives of creatives better. Caution a non-compliant person or entity in writing. Sanction a non-compliant person or entity by the imposition of administrative fines. I think that will be done in collaborations with the collective management organizations such as AVRS, MCSN, and REPRONG as well. So if you get such letter, make sure you engage relevant bodies just to know why you're getting such sanctions or letters. They can also institute criminal proceedings against a non-compliant person or entity, civil actions against defaulting person or entity, obtain a court warrant or order to seize or detain any book, record, document, or other information storage system or database which use does not conform to the act. So any authorized use they have and they get a court warrant to do that, they're going to detain and seize your work. And I'm happy to see all of this, because I follow the Kenya Copyright Board's activities online, and I'm like, we need more information. So maybe more publications, more actions. Maybe they can also reach out to the IP community for volunteers. I will always volunteer, just to build capacity. But yeah, that is part of their work. Then section 86 sub 2 talks about appointment of copyright officers. So let's see now. So copyright officers who um so who have the right to enter, inspect, or examine any reasonable time. Reasonable time will be between working hours, definitely. Any building or premises. So recall that one of the powers that the NCC has is to get court warrant to do search, to seize, and all that. So they will then work with their copyright officers who are already appointed to assist them to do all of this, to arrest any person who they reasonably believe to have committed an offense, make such examination and inquiry, demand the production of any record to be kept under section 48 for inspections, demand information, require the person who is defining the building to give such information. And then anyone who goes ahead to obstruct these copyright officers, you prevent them from carrying out their work. It's like when the police tell you any obstruction, if you cause any obstruction to their investigation, you also be liable. So make sure that you do not obstruct or hinder them or prevent them or even go as far as assaulting. So the other day my mom was telling me a story of how this PHC, and that's the Port Harcourt Electricity Company, were assaulted in my community because we've been having some light issues. So if you assault a copyright officer who is carrying out his duty, that's not going to be fun for you going forward. No more intimidation from offenders. If like carry your dog, I mean we saw a lot of that during the elections where people were trying to protect themselves, but I mean that's understandable, but not in this instance anyway. Don't do anything that will make their job difficult. So yeah, they have the powers, the rights, and privileges of a police officer as defined under the Police Act or any other relevant enactment relating to investigation and prosecution of a criminal matter. Remember I talked about registrations of work, so you can check out. Okay, let me just save that for later. Okay, yeah. Section 85 says 87 rather states that they have the right to maintain a register of work. So it reads, the commission shall establish and maintain a register of work referred to as register, and then any person that applies in a prescribed manner to the commission to register a work that is eligible. So anybody can apply. The commission may also enter the particulars of the work in the register, provided the registration was not done. The registration of the work does not confer copyright. Then sub 4 says register shall at first instance be evidence of work, and particulars entered in the register and any extract from the register certified by the commission shall be admissible in evidence in all proceedings without further proof of production of the original of the matter. So my dear copyright owners of literary work, musical work, artistic works, audiovisual works, broadcast, and sound recording, even though the law states that you may register, in the event of a dispute, the commission will come to your aid. They'll be like your helper. They'll be like the ladder that you need to use to enter heaven, because now it states that the certified copy that you get from the commission shall be admissible in evidence in all proceedings without further proof of or production of the original of the matter certified. So it doesn't matter if you have another copy in your house. The one that is being certified by the commission is what can be tendered in the event of a dispute. You also have the power to produce and store all or any part of a registered work electronically or in any other format, which is good. I mean, we have to move from analog to the digital, thinking of storing. I think if they are saying any other format, I would want to say maybe the format will also include like a blockchain registry for copyrighted materials. Then they also have the commission may, with the approval of the minister, make regulation for the purpose of this part. So you see, I mean, so much to do. So anyone who knowingly makes or causes to be made Anyone who makes any false entry into the register commits an offense under this section is liable to a conviction, to a fine or at least a fine of at least 100,000 or imprisonment for a term of at least 1 year or both. So if you know that you do not own a copyrighted work, so I think what comes to mind is the copyright, the gospel kids I talked about. Trying to remember, so it's between RCCG choir and some other guy. You guys can check that. I talked about it in one of my podcasts as well. So let's say in that case, RCCG went ahead to deposit a copy with the Nigerian Copyright Commission. Now, if you knowingly, like on your own, you just chest and say, "I go register this work as my own," that you've made a false entry, and you are liable to a fine of 100,000 naira. It might be small, but it's not small. It's going to dent your integrity. You get. So yeah. Then section 88 sub 2 on their road to approving a collective management organization. The commission may approve a collective management organization as long as they're satisfied that it is a company incorporated, as a limited by guarantee. Its objectives are to negotiate, grant copyright licenses, collect royalties on behalf of copyright owners and distribute such royalties, represent a substantial number of copyright owners, and then comply with the terms and conditions prescribed by the regulation made by the commission under the act. So the regulations, the CMO regulation has not been published, so looking forward to seeing what is going to be included there. But I know the previous CMO regulation was very detailed with regards to IP ownership, and also I think this section also cures it makes reference to the COSON MCSN dispute. Currently, MCSN, which is the Musical Copyright Society of Nigeria, is a recognized collecting body for musical works. Then sub 6 also talks about the commission shall have the power to suspend and revoke the approval given, like the suspended COSON's license years ago, and they also have the right to review and approve tariff as may be determined by a CMO. So I think that might also be included in the regulations as well. So I would patiently wait for the regulation to know what the tariffs are. But then you can also look out for the manual I had mentioned, which is the licensing and operation manual for collective management organization in Nigeria. That was published last year before this law was passed. Then they also have the right to make regulations specifying the conditions necessary for the effective management of CMOs and to give effective purpose of this section. So CMOs approval, review of tariffs and etc. So why this is important again is that, so I don't know if you guys were aware, I think during the pandemic, during the lockdown, there were publications on, I think it was a CMO in Kenya or one of these African countries was accused of not being transparent and all. So this is where the copyright commission or the agency, the copyright board, would come and intervene to make sure that a CMO is doing their job. And just a few days ago, I don't know how many of you know Sotiso. They are a Nairobi, Kenyan band. They were calling out their CMO for, so to them the royalty they got was so little, and it became like a, so he went ahead and started trolling his artists who were upcoming, saying he wondered what one of them, what's his name now, I'm trying to get his name, guys, just bear with me for a minute. So, but one of the Sotiso's bandmates, Bien Amir Baraza, was trolling another artist, saying if he got 14,634 shillings, he wondered what the guy himself got. And then the band is now threatening to withdraw their membership. So I think the regulations will take care of that, because the previous regulation said that what copyright owners can do if they don't wish to be affiliated with a CMO anymore. Section 90 talks about the powers to constitute a dispute resolution panel to resolve issues on payment of royalties, terms of licenses, and any other matter. And then sub 5 says it can make regulation for the procedure and operation of the panel. So looking forward to seeing all of those things being included into. So this is like what the Nigerian Copyright Commission is expected to do going forward. So next up on my list for conversation is the introduction of the special exception for people that are blind, print disabled, visually impaired, those category of people referred to as beneficiary persons under our law. Now, one interesting thing I got to find out in the course of my research is that our law that makes provision for these beneficiaries is also enshrined under section 31A of the UK Copyright Act. So it reads, disabled persons copies of works for personal use, making, communicating, making available, distributing, or lending of accessible copies by authorized body. So there's 31BA as well, same thing. Then accessible and intermediate copies, records and notification, interpretation, and general. So if you look at it, the definition for what is an accessible copy, authorized body, is also similar to what we have under section 26, sub 7, which defines what is an accessible format copy, works, authorized entity, beneficiary persons, and that's about it. So I'm just going to take my timeline to explain each of the subsections and kind of link it back to the relevant provisions under the UK Act. Given that we borrowed most of our laws from it, I think it's I would say it's sweet that we have to go back again to reference it, but then these are some of the things you find out or come in contact with when you are reviewing law. So why is this section really important for us in Nigeria? Why am I commending the drafters? So basically, we've joined a league of other countries that have made provision for copyright provision for blind and visually impaired people who always have difficulty in accessing copyrighted works in format that are accessible to them, such as braille, audio, or large print. So I do recall an incident last semester while I was invigilating master's students in my school. So we had this visually impaired students that had to come take exams. So she had to come her own laptop that had its own tech that would help her be able to type her work and interpret what would be read to her regarding the questions. And at some point, the laptop she had, the battery wasn't strong, and then there was no light, and then she couldn't finish her exam. But the lecturer was gracious enough to ask her to come the next day. He would set a new question for her to be able to complete her assessment. So those are some of the things that this law seeks to cure, to make sure that institutions, NGOs, or authorized entity as defined under subsection 7, to include government institutions or non-profit organizations or recognized bodies by the government who receive financial support from government to provide education, instructional training, adaptive reading or information access to beneficiary persons, can be able to have access to all of this. Now, to address this provision, the World Intellectual Property Organization had adopted the Marrakesh Treaty to facilitate access to published works for persons who are blind, visually impaired, or otherwise print disabled. This treaty creates a legal framework that allows the cross-border exchange of accessible books without the need to obtain permission. We know that when you're talking about intellectual property of any format, consent, permission, authorization is very important. But because of these beneficiaries, certain exceptions have been put in place to make sure that they do not lack or access to information or copyrighted work are not restricted from them. So you kind of give them special privilege. They have the special privilege to access works with and jurisdiction, your territory, is not a barrier to you getting this information. So member states are required to provide exceptions or limitations in their national law, which Nigeria has done under Section 26 now, to enable the reproduction and distribution of accessible books by authorized entities such as libraries and NGOs. This Marrakesh Treaty came into force in 2016, and then Nigeria ratified it 4th of October 2017. And as at April, as at this month, there are about 75 countries who are member states and have also, considered putting this into their national law. This law per se, or this provision, helps to promote right to education, information, and culture for people with disability. And in addition to this, you also have other laws that promote access to information and culture for people with print disabilities, such as the UN Convention on the Rights of Persons with Disability, the World Intellectual Property Accessible Books Consortium, and several other laws. So what does our law provide? Section 26 of the Copyright Act 2022 states that an authorized entity of the government, so it says an authorized entity or government recognized entity that receives some sort of funding from the government to provide education, institutional training. I think I read that in between. With the intention of not making money, can, without the permission of the copyright owner, literary and artistic work in form of text, notation, or related illustration make or obtain an accessible format. So what is an accessible format? This will be a copy of a work in an alternative form or manner that gives the beneficiary person access to use the work. So for instance, the Braille, audio, any other formats that would help these beneficiaries be able to access these works in question. Whether it's also by electronic communication by wire or wireless means that is supplied to the beneficiaries, exclusively and for non-profit purpose. So let's do a brief reading. So Section 31A of the UK Copyright Act would went as far as elaborating to say the copies are usually made for personal use. So you making copies to give to them is so that the beneficiary or disabled person has access to either substantial part or the whole work itself. You're able to enjoy using it within your own comfort. You're not your use will not constitute an infringement. And it goes further to say copyright is infringed by the transfer of an accessible work made under section to any person other than persons. So if it's given to someone that is not disabled or considered to be a beneficiary as defined under section 26 of 7 of the Nigerian Copyright Act, to include the blind, someone that has visual impairment or perceptual or reading disability, which cannot be improved to give visual function substantially, or through physical disability to hold or manipulate a book, or to focus or move the eyes to the extent that would be normally accepted for reading, then that will be considered to be an infringement. So you now have to state your purpose for wanting to reproduce, to make copies in that format. And I think that if someone sees you making a braille, an audio version for this special persons or beneficiary, they would definitely understand. Now, if you look at sub 7 of the UK Act, it says in this section dealt with means sold or let for hire or offered or exposed for sale. Then let's an authorized agent or an authorized or government recognized entity to do certain things in Nigeria without consent, permission, authorization of the copyright owner in a literary artistic work in form of text or whatever. Then you also have criteria for entities who wish to explore the special exception, so that we are able to the commission is able to control who can do certain things, who can provide accessible formats for beneficiaries. Now, your aim must be to serve beneficiary persons. Distribution is limited to just beneficiaries. You also discourage reproduction, distribution, and making available unauthorized copies, and must be maintained with care. The record of handling, the record of the copy must be properly documented while respecting the privacy of the beneficiary. So one thing again that I liked about the Copyright Act is right to privacy for beneficiaries. We don't want people being all up in their business. Oh, so now this person will carry and give. No. And I'm glad that the Copyright Act thought about that as well. Especially now when we have issues as to transfers of data, data privacy, data protection, and the Nigerian body. So we now have like a data protection bill, which I skimmed through it while I was preparing for one of my lectures, and I would say at this time it kind of takes care of our present data issues. So yeah, categories of beneficiary persons according to subsection 3 states that they are allowed to make a copy of the books or the copyrighted work they have access to, as long as it's for their personal use. So you recall that I stated the UK Copyright Act specifically made provisions that work for disabled persons should be for personal use. If it's not for personal use, then it's going to be an infringement. Now, if you are a caretaker, if you're a caretaker or a caregiver of a beneficiary, you are expected to assist. So just like the story I told you about, this student had a caretaker who was her sister that brought her to school, but she wasn't allowed to stay with her to write the exams. She had to come later on, but she follows her around and all that. She assists her to get I would say the materials she needs for lectures. Now, the beneficiary in making copies or accessible formats must have consent to use, lawful consent and lawful access to use the work. It also permits cross-border exchange, distributing and making available accessible formats copies exclusively. So you find out that this license per se is exclusively for people with disabilities that have been listed under the act. They are blind, visually impaired, or print disabled. They also need to take appropriate steps to discourage the unauthorized reproduction, distribution, communication to the public. Um, um, they also need to take into consideration um, what the laws provide in other jurisdictions in terms of accessible format. Um, Provided that prior to this they were unaware based on a reasonable ground that it will be used by another person other than the beneficiary. So if for instance they give or make copies and it gets into the hands of someone who's not a beneficiary, there must be reasonable ground to show that they were not really aware about that. They also need to, sub 6 gives an entity or beneficiary or caregiver the right to import an accessible format either through wire or wireless format without the permission of the copyright owner, and are restricted to literary and artistic work. I don't think the UK Copyright Act restricted this. Let me take a quick look. Not seeing anything about restriction, but in terms of accessible and intermediate copies, records, and notification, it states that a person listed in sub 3 may request an authorized body to make accessible copies, intermediate copies, and the person must be a disabled person, another authorized body, or a right holder. They must list the work that they want to access, the name of the contact detail. But yeah, nothing specifically, clarifying the kind of works that are restricted to persons with disabilities. Now, another thing that also struck my mind is the integrity or moral rights implications, whereby the artistic work it was respected or is respected when there's a need to change certain things so that it's accessible to a beneficiary in an alternative format, and this is in line with section 14, which talks about an author's moral right. So moral right gives you, that's under our own law now, moral right gives you exclusive right to detect and prevent any form of distortion, mutilation, anyone that attempts to change certain elements regarding your literary or artistic works. So subsection 14 will read, says the author of a work in which copyright sources has the right to claim authorship of the work, in particular that is authorship be indicated in connection to any of the eligible works. It has the right to object and to seek relief in connection with any distortion, mutilation, or modification, or any other derogative action in relation to his work where such action would be or is prejudicial to his honor and reputation. So I'm basically focusing on section 14 sub 1 paragraph B, and it says a person has the right to object to a work being falsely attributed to him as an author. So with regards to beneficiaries getting access to their work, when you are getting it, you need to get the consent of the author to actually change certain things. So let's say maybe you're trying to translate or put it into the accessible format and you're not getting the right interpretation, then you need to reach out to the owner of the work to say, oh, this is what I want to do. The work may be mutilated, but not to cause you harm or or damage to your reputation. And again, moral right according to our law now, that's the Copyright Act sub 3 says not transmissible during the life of the author, and upon death of the author be transmissible by testimony, disposition, or operation of law, and shall subsist for the duration of the copyright in the work. So if it's literary work is 70 years after the person dies. So lifetime plus 70 years after the person has peme. You don't go. But yeah, I would say benefit of this addition to the law the benefit of this addition to the law. Just hold on, guys. Trying to get to something. So, if you agree with me that this law makes sense, please let's when you listen to this, but just be clapping for the drafter, because it's not easy to think of all these things. I mean, I've been involved in drafting of a law, and I will tell you, comparing different laws is not my mind. You get, it's not Benz. But yeah, so what would you say is the benefit of having this law included in the new Copyright Act? So one of the other benefits would be more advocacy and awareness raised among governments about the obligations that Marrakesh Treaty provides, maybe more technical assistance and capacity building for authorized entities and users to facilitate the production and exchange of accessible books. And then there need to be some sort of monitoring and evaluation of the impact of the challenges of the treaty and Section 26, and coordination, cooperation amongst authorized entities, right holders, and users, so that um, Nigeria is able to invest in enough resources and infrastructure to be able to produce and distribute accessible copyrighted materials such as literary and artistic works that um, beneficiary persons would definitely need. But yeah, that's about it for section 26. Let's move on to the exceptions for non-commercial purpose. So for every rule, there is an exception, and for copyright, you have exceptions which fall under non-commercial use, where you do not intend to make profit from the use of a copyrighted work. Now, this will include um, when it's for private use. We talked about that when we're discussing the beneficiaries, where um, making accessible formats available to them must be for private use. Then there's parody, there's satire, there's caricature, there's non-commercial research and private study, criticism, review, or the reporting of current events, um, subject to the condition that if the use is public, it shall, where practicable, be accompanied by an acknowledgement. So basically, if you're going to do all of the above that I listed, you have to acknowledge the work, list the title of the work and the author, except in an instance where it was incidentally included in a broadcast. And broadcast is a type of eligible copyrighted work. Now, it's now be expressly stated in our laws that exceptions to copyright uh, can be identified or called fair dealing. However, factors to determine whether the use of that work will fall under fair dealing will be: one, you looking at the purpose and character of its use, the nature of work, amount and substantiality of the portion used in relation to the work as a whole, and effect of the use upon the potential market or value of the work. And this is also similar to the four-factor test that is being used in the US and some other jurisdictions. I do recall that I had referenced this when I was discussing the Andy Warhol case. Andy Warhol case against the so it's I'm trying to remember the name of the case, but yeah, I just recall the first part, Andy Warhol, which is an interesting case with regards to photography, so you guys can check it out. I think I talked about it in my podcast on Twitter, and also on my blog as well, my newsletter rather. But then moving forward to other provisions, that the use of a work will not be considered to be commercial will be including it in an audiovisual work or broadcast of an artistic work in a place that it can be viewed by the public, um, where there's an incidental inclusion of an artistic work in an audiovisual work or broadcast, quotation in form of short excerpts from a work, um, you know, reading or recitation in public or in a broadcast, not for commercial purpose or for any reason, extracting from a published literary work. But then you must always acknowledge the title of the work and the author. Where you also make use of the work under the direction or control of the government or by public libraries or non-commercial documentation centers or scientific or other institutions. But the long and short of it is that the use of that is for public interest. As long as you guys do not intend to generate revenue and it does not affect the potential market or value of the work in question. Where you're also going to be reproducing a work either by the direction or control of a broadcasting organization, um, where it's intended to be exclusively for lawful broadcast, and then it's destroyed before the end of a term of 6 months following the making of a reproduction, or longer periods may be agreed between the broadcasting organization and the owner of the work in question. That reproduction of that work um, may, if it's not an exceptional documentary character, be preserved in the archives of the broadcasting organization. It shall not be used for any other purpose without the consent of the owner. So you see that even with all of these things, you shall still need to go back to the owner of the work to discuss with them and say, CEO, I want to use your work for broadcasting. This is what we're going to use it for, which will also be included in your agreement. Lawful broadcast will mean broadcast that does not infringe on a copyrighted work. News of the day for public broadcast or publicly communicated by other means. And then any use of work for the purpose of judicial or legislative proceedings or the reporting of such proceedings will not consider to be will fall under the fair dealing principle and not for commercial purpose. Now, when the use of the work is for when you're making you're making not more than 3 copies of a work. So for people that like to go to business center, photocopying centers, you want to make copies of a full book. Now the law has expressly said that you cannot make more than 3 copies of a work. 3 copies of a work by or under the direction of the person in charge of the public library for the use of the library where such work is now available for purchase. So if, let's say, you're looking for a particular article or journal and it's not available in the library, you're only entitled to 3 copies of that work, which you have to go and make photocopies for. Reproduction for the purpose of research, private study, or an unpublished literary or musical work that has been kept in a library, museum, or any other similar institution which the public has access to. Transient or incidental reproduction with an integral or essential part of technological process whose sole purpose is to enable transmission in a network between third parties by an intermediary or for other lawful use where such use has no independent economic significance. Use of an artistic work in form of building model or a drawing or a plan or of a building for the purpose of reconstructing. So if you want to reconstruct a building, you can use an artistic work in form of the building model as long as you're not going to commercialize it. Where the use is for the benefit of a person with disability, already stated in section 26, and is for non-commercial purpose, but is specifically required for the specific disability, whether it's a print or visually impaired or blind. And then when you're communicating or making available the work or materials of it that is subject to purchase or licensing terms to members of the public for the purpose of research. So if, let's say, the work in question you have is subject to a purchase or has licensing terms, if you're going to be using it for research purpose, private use, on the premises of publicly accessible libraries or educational establishment, museum or archives, as long as you're not going to commercialize it, then that's fine. you're going to be commercializing it, then you need to still reach out to the copyright owners to get their consent to commercialize what you want to do. Then you then have reproduction of a copy or adaptation of a computer program is permitted, so long as the purpose for that is to use with a computer for which the computer program was obtained, archival purpose, or you're trying to replace an original copy that was lost, say an original copy of the computer program that was lost, destroyed, or rendered unusable. That's when you're only allowed to adapt or copy a computer program. If it was destroyed as well, you're allowed to do so, but with respect to any other computer program that is not necessary for the machine to be activated, such program or part is not accessed or used other than to make new copies, and any other contractual term which purpose restricts you from doing any of the permitted acts. So long and short, when it comes to non-commercial use, there are certain acts that the new Copyright Act has listed as permitted act that you can do. So if you want to make copies of a computer program, you have to make sure that it's because the original is missing, it's been destroyed, it's no longer available. All of those things need to be taken into consideration. You also need to acknowledge the author of the work. So that's about it for the general exceptions under the Copyright Act. So the takedown notice as found under section 54 of the Nigerian Copyright Act is kind of similar to the DMCA takedown notice, which is basically for protecting copyrighted content online. In the US, it's contents that are copyrighted are removed from website or internet platform at the request of the owners of the work. And under our laws as well, it seeks to tackle intellectual property infringement carried out online, especially now where it's easy for anyone to just upload, download, stream, and do all manner of things when it comes to your copyright content. It also gives the copyright owner the right to issue a takedown notice, like I stated, is similar to the DMCA notice, requesting that the infringing content be removed online. Now, is there like a possible alliance with relevant stakeholders to enforce this when we get our first viral? I think we should be getting our first viral takedown notice. I mean, it's been happening, but not formally, because we did not have a law that made provisions for outright takedown of copyrighted content online. You also find that most jurisdictions or countries tend to come up with their own because they felt that the DMCA takedown notice, its proceedings and all of that were a bit too stiff or technical. So countries rather come up with their own format than rely on the DMCA, which lists certain materials they considered to be contents that can be removed. For instance, user-generated content from platforms like Facebook and TikTok, especially when they get that request. You also need to check out your terms of use and privacy policies that you just click agree to. Then website owners who get the notice from the DMCA, from the website owners or the hosting company, where the website owner, upon receiving the notice from the copyright owner or content owner or distributor or publisher, or from the internet service provider or the hosting company, or where an infringing website is taken down from offline by its hosting company. This occurs between the website owner who does not voluntarily comply with the takedown notice as described. So that is the DMCA format. Now let's bring it back home. As a copyright owner, this is your right to request that internet service providers take down, disable any access, any unauthorized and illegal access to your work hosted on their platform or website. How do you commence a takedown notice in Nigeria? First, you'll be required to do a written application. You then have to include like your physical or electronic signature of the person authorized to act on behalf of the copyright owner, identify the work claimed to have been infringed, identify the infringing material or the subject of infringing activity that is to be removed. You need to put in personal details like your name, address, phone number, then do like a declaration on oath that the that you believe that it is your work that was being used without your consent, or that you're acting on behalf of this person because he authorized you to act as his agent. And then a statement that the information you stated in the notification is accurate, and that you have been authorized to act for or on behalf of the owner of the copyrighted work. So you see that it looks easy, but it's not really easy at the same time. There's also like a preliminary conversation or meetings between the ISP and the alleged infringer, and all that. Then for someone, so the process for taking it down after they've gotten your application for notice of infringement under section 54, they will notify the person saying, oh, this person is accusing you of abusing their work and we're going to take it down. So they give you some sort of room to come and plead or respond to the notice. They don't just arbitrarily they don't just remove it like that without pre-informing, but sometimes it can be done, and then you'll be notified that, oh, this is the action that the ISP has taken. The service provider may resume access to or restore the content or the link that if they receive a counter notice from the subscriber that which he has forwarded to the owner, the copyright owner, or received that they did not receive. If they did not receive within 7 days after forwarding the counter notice a response from the person that laid the complaint, they will restore the content back. The service provider must, or like the law stated, shall take effective. Oh gosh. The service provider shall take effective steps in accordance with high industry standards to prevent any content taken down or removed under this provision to be reloaded. Now, one thing again that I found really interesting while comparing the US DMCA and the Nigerian takedown notice provision is that under the DMCA, they were clear as to the type of informations that can be considered. So you know when you say your copyright taken, so they clearly listed out the type of information that one can report. So such as your URL links, the source of the URL, description of the ownership, how the work was being used without your consent. Whereas in our old law, it stated that the copyright owner just needs to identify the subject. I think that's a bit ambiguous, but that's my personal view anyways. The DMC also listed who could file a takedown notice to include the content creator, the owners, copyright owners, NFT owners. See, they're thinking like, sorry, let me not say they're thinking. Oh my god, so sorry guys. I think for them they'll be proactive because of the kind of terrain they are in. And like I initially stated, our present copyright law tackles our current issues. So moving on, code writers and publishers, social media users and participants, subjects, they must also include subject contained within the content and the work that was published without permission, content publisher or distributor. Whereas section 54 just stated that the person authorized to act on or on behalf. So if you want to be strategic, you can say, oh, this person that's acting on behalf of this person is a publisher, is a distributor, he's an NFT owner, is a content creator, etc., etc. I would also say that we played it safe by not listing the type of content um, that can be, reported to the ISPs and all that. So that is just my comment and feedback for this section rather. But if you look at subsection 4 of the act, it states that if someone is dissatisfied with the decision of the service provider, they can apply to they can refer the matter to the Nigerian Copyright Commission for determination. So you see that they have a right of appeal. I think I said that when I was talking about the role of the commission as well, powers, and that has been expanded. Then also said the service provider shall not be liable to any person for any action under this section in good faith. And I was like, how do you then define good faith? But maybe I'm just overthinking it. Then finally, sub 6 says service provider who fails to comply with the provision in sub 1(2) shall be liable for failure of such a breach of statutory duty and infringement of the content which is the subject matter of the notice under section 54. So yeah, there you have it on take down notices. Then for instances where you have like a serial infringer, the service provider upon receiving that will send a letter in writing warning the subscriber that he has been identified as a serial offender. I do recall while I was doing my master's that we had gotten a letter from a former housemate about him using copyrighted materials and all that. I think they asked him to come and face a panel or something. Can't really remember the details, but something similar to that. And the person who gets the warning notice can challenge on the ground of mistake or misidentification. He has to do that within 10 days from the date of receiving the warning. He has to send a counter notice to the service provider, including his contact details and the real fact about his account which has been misidentified, and the basis for challenging it. And if the basis for challenging it cannot be resolved within 10 days, the matter shall be referred to the commission. So the commission also, is actively involved in all of these things. Then the service provider acting in good faith in suspending the account of a subscriber relying on information contained in notification referred to in sub 2 shall not be liable to anybody for any claim based on the suspension. So if the service provider say, this is an issue, let me help you guys, because it's just like the SpongeBob case where YouTube had to take down the video within 24 hours and later restored it back. I know last time I checked, they had like 1 million plus views on the SpongeBob fan work that was created. Misrepresentation, when the person has been misrepresented under this section, that's under section 57, and that material infringed or activity is infringing, or the material was removed or disabled by mistake or misidentification, is liable in damages for injuries suffered. So you still have some sort of remedies if there was some sort of misrepresentation, but then it doesn't state who would be liable. I think it's the copyright owner who will be held liable for this misrepresentation, because they are the one that's triggering the notice first of all. So yeah. So prior to recording this episode, I was going through the act one day and a particular section just caught my eye, and I was like, And I think the previous day as well, 2 days before there was this UK case that someone had shared, and I was like, okay, I think this actually goes. Let me read this again and see how it relates to us in Nigeria, and it kind of fit for me. So When I posted it, I was like, what is the function of functional shapes in Nigeria um copyright law? So what do you think when you read section 10 sub 2? So let's read it together. So it says the protection of three-dimensional work of artistic craftsmanship shall not extend to its functional aspect. Three-dimensional work of artistic craftsmanship. I mean, if this was to be an exam question, I'm pretty sure my students would be like, Henry is wicked and all that. But this is what the law now provides. So I decided to take a deep dive into it just to, enlighten myself and also um be well prepared when I get asked that kind of question. Majorly, when you hear of functional aspect of um, a creative work or an intellectual property, two things might come to your mind: um, industrial design and patent. Um, but that seems to be more geared towards industrial design or patent design for jurisdiction like the US. So basically, many countries will protect functional aspect of an artistic work. Artistic works are already copyrighted, but they're eligible for copyright works. Um, and just hold on, guys. Let me just reconfirm this. And yeah, and Section 10 is actually talking about um the exclusive rights that the owner of an artistic work enjoy, which includes to reproduce the work, to publish it, to include it in the work of an audiovisual work. So when I talk about audiovisual work, I am referring to cinematograph works. So let it not sound foreign to you guys. Um, you also can broadcast it, you can communicate the work to the public, you can make the work available to the public by wire or wireless means. You can also make an adaptation of the work or do an adaptation of the work, do in relation to an adaptation of the work any of the acts specified from 1A, B, and C. So that is it. That is that on um, exclusive rather than artistic work on. But let's get back to our question: what is the functionality of a what is a function? What is the functionality of an artistic work under the Nigerian Copyright Act? Does the new Copyright Act make provision for the protection of functional aspect of an artistic work? And the answer is hell freaking no. And that is because artistic works would include paintings, drawing, etchings, lithographs, woodcuts, engravings, prints, work of artistic craftsmanship, pictorial woven tissue, works of architecture in the form of building models. You get, and there is no functionality or responsibility, that is attached to that. And this is because the copyright principle is based on the expression of a work, an original character in a tangible format, and copyright is focused on encouraging creatives to keep expressing their works or keep using their human intellect to create works. It also protects the right of the authors to ensure that they're not just rewarded but recognized. And as like we saw as part of the aims of this new act, it seeks to reward and recognize any human intellectual effort. Whereas other intellectual property mechanisms such as industrial design, patent right focuses solely on protecting the investment of the functional aspect of the artistic work against imitation and unfair competition. Copyright will focus on unauthorized use. Patent and industrial design will focus on protecting imitation and unfair competition in the market. And one of the ways that creatives can protect functional aspect of an artistic work is by obtaining an industrial design, which I stated. Industrial design is a type of intellectual property mechanism that must be new and novel. The combination of lines and colors, yeah, and helps prevent other people from making, using, or selling similar designs without permission. So the shape of my laptop, the uh, design of my mic, is a small mic anyways. um Additionally, trademarking the design name or logo can help you distinguish your brand from another one. It's also important that you consult an intellectual property lawyer to advise you on the best way to protect yourself. Now, um if there is no copy available in Nigeria, um so this, and I'm going further to talk about um, copyright in a work of architecture, where the exclusive right to control the erection. It can also include the exclusive right to control the erection of any building, which reproduces a whole or substantial part of the work, either in its original form or any other form recognizably derived from the original, but not the right to control the reconstruction. So an architectural work was an artistic person who creates an architectural design or model has the right to control the direction of how the building will be used, where you can use all or some part of the model, but he cannot control any reconstruction. So in the event there's a natural disaster, an act of God, he cannot go and say, oh, you cannot use the same style of the original building. um you know, you cannot reconstruct it. He really doesn't have the right. But then, moving forward, if there's no copy available in Nigeria that has been put on sale for 6 months, the Copyright Commission can issue a compulsory non-exclusive license to reproduce and publish an artistic work um, after its expiration from the date of first publication for certain purposes, but will be sold at a lower price after paying same fees to the commission and calculated royalties in respect of the copies for reproduction to the owner of the artistic work. So I already talked about the exclusive right that an artistic owner enjoys. So that's about it for whether or not functional shapes or designs or three-dimensional works can be the functional aspect of a three-dimensional work can be protected under the Nigerian Copyright Act. Have you ever heard of the levy that's being placed on copyright material? Now, let me explain. This was formerly found under Section 40 of the Copyright Act 2004 that was repealed and amended. Now, in 2012, Nigeria joined other jurisdictions to create a copyright levy order 2012, so that they could impose some sort of percentage on gadgets, devices that can be used, that can or may be used to infringe copyright in a work, such as CD, compact disc players, photocopiers, cameras, mobile phones, software, computers. Now, under the new act, the levy on copyright material can be found in Section 89, and it states that there shall be a levy on any material used or capable of being used to infringe copyright in a work. Now, this levy is payable under subsection 1, and any exemption from such payment shall be as may be prescribed by the minister. The levy payable on shall be subject to approval, deduction to be paid, approved deduction to be paid into the fund of the commission, and the commission shall have the power to reimburse the funds. Material in this case, in this instance, will include objects, equipment, machines, contrivances, or any device, including electronic or digital system, used or capable of being used to infringe copyright in a work. Remember again, like I stated, this present Copyright Act protects or was created to solve our current issues. So you find out that certain devices that you have already have some sort of tax fee levied against them. Now, how did this come to be? We already know that copyright gives the holder the right to authorize and control any form of reproduction, publication to the public. Now, in an event where someone, or in this present era rather, where ease of reproduction is what is trending, how do you then protect yourself? Now, let's link it back to technological protective measures, which is also found under section 50 sub 3, which defines technological measures to be a technology, device, product, or hold on, let me get it. Yeah, I think I just passed it anyways. So 50 sub 3A says technological protection measure means it's technology, device, product, or component that is incorporated in the work designed to effectively prevent or inhibit the infringement of any copyright. So you see that the act not only did not only go to make provisions for online infringement, but also being proactive, especially in this digital era where anyone can decide to want to bypass or remove protective measures that you've put in place to make sure that no one infringes on your work. So it goes further to define, circumvent technological protective measures to be where someone avoids, bypass, removes, or deactivate or decrypt any technological measures that have been put in place by the copyright holder to prevent any form of infringement. And it goes further to say a technological protection measure protects a work under the Act, and if the measure is in the ordinary course of its operation, controls access to the work protected, or prevents or restricts any acts that are not authorized by the author's consent or permitted under this section. It does not extend to measures which in the normal course of operation only controls access to a work for non-infringing purpose. Non-infringing purpose would be for non-commercial purpose. You're not making money from it. And it goes further to state, this is like an exception, and say for a non-profit library or archive or educational institution which gains access to a commercially exploited copyright to make good faith determination or whether to acquire a copy of the work for the purpose of engaging in conduct permitted. Conduct permitted would be private use as stated under section 24 general exceptions. But then that work cannot be retained longer than necessary to make the good faith determination. It cannot be used for any other purpose that is permitted under the Act. Now, the introduction of good faith determination, where a non-profit library is, I would say it's new, but then I think the law should have gone further to define what a good faith determination would be, just to prevent any form of, confusion if someone claims that they don't really understand what is actually happening. Then subsection 5 makes provision for an exception where there's an identical copy not available in another format. The permitted act is lawfully authorized investigation, but it doesn't state who can sanction this investigation. Now, in the event where you get consent, permission, authorization to use a computer program, you're also allowed to use technology measures to gain access to a particular portion of that program for the sole purpose of research to identify and analyze and exchange information and mutually use information with other programs. Then there's a dispute resolution mechanism under section 52 sub 1, which states that the copyright holder can commence action. The copyright owner can commence action at the Federal High Court, which has the jurisdiction to hear IP-related disputes, and the remedies available includes damages, accounts of profit, and also they can get an injunction in an action for circumvention of technology protective measures, liable for a term of 1 year in prison if the person makes or imports into Nigeria any technology or device that can be used to carry out acts that are considered to bypass the technological protective measures that the copyright owner has put in place. The person will be liable to a fine of 1 million naira, imprisonment for a term of at least 5 years or both. Now, if you also sell, hire, distribute tech or technological any technology or device used for circumvention or a technical protection measure, you will be liable to a fine of 500,000 and a term of at least 3 years or both. And if you're also in that line of business that sells, hires, render services that assist people to bypass protective measures already put in place by the copyright owner, you could be liable, or you shall be liable to a fine of 200,000. I think it's too small. Or a term of 1 year or both. So kudos again, like I said, to the copyright owner. Then look at section 51, talks about falsification, alteration, or removal of rights management information. So basically, in an instance, if you knowingly remove or alter any information that identifies a copyright owner, if you sell, distribute, you import for distribution any copyrighted work or copyright subject matter, the number or the code included in connection to communicating to the public without the authorization, permission, and consent of the owner, you shall be liable to a fine of not less than 200,000, imprisonment for a term of not less than 1 year or both. So you find out that for issues or infringement relating to private levy on copyright materials and technological protection measures, there is a minimum sanction that has been set aside by the law, and sub 3 of 51 defines right management information to include any information that is attached or appearing in connection to communication to the public. Information could be who the author is. So if you go and falsify, knowingly remove set this information so it can aid or enable or facilitate or consist some sort of infringement of a copyrighted work, you are liable to a term of not less than 1 year. So that's about it for copyright levy and TPM, I would say. But if you have further questions, you want to talk about it, trying to understand where the origin of copyright levy began in Nigeria, I think we can just check out certain research work. I think I came across a publication by Dr. Ifeoluwa A. Olubi. She wrote the compilation of IP laws in Nigeria. So I believe she's working on the amended version to include the new Copyright Act and any other regulation that will be included as well. So if you haven't bought the previous one, the copies, you can look out for the second edition, which, like I say, she may be working on. I'm not going to, I'm not certain, but I know she will be working on that. So what is definitely, so just to conclude, what's the justification for a levy on copyrighted? I mean, we are practically in the digital era, so it's very important that we're able to negotiate some sort of costs that can be attached to all of these devices that aid the use of copyrighted work. You can also help the copyright owners to enforce their right against private individuals. So you find out that the commission is not acting as a middle person to help the copyright owner. It will also benefit the copyright owner financially. It can also reduce the rate of exploitation of copyright and neighboring rights within Nigeria. So yeah. Now, if you're an actor, you're a singer, you're a musician, dancer, you can deliver, interpret, or perform literary or artistic works or expression of folklore, doesn't matter the format of the work, then this section that I'm about to review is for you. If you partake in dramatic performance such as dance, mime, musical performance, reading or recitation of literary art, or any similar presentation, which is a live performance given by one or more individuals, then section 63 to section 73. That's 10 chapters dedicated for you, whereas in the previous act we had just 5 sections dedicated for performance rights, or otherwise known as neighboring rights. So let's start with the introduction, which is under section 63. Now, under section 63, the act provides that a performer shall, so is mandatory, exclusive right to control how his performance is used, whether it's the fixation of his unfixed performance or reproduction of a fixation of his performance in any manner or form. If the original fixation other than the fixation excluded in section 68 from the necessity from obtaining consent of the performer was itself made without his consent. Reproduction is made for the purpose other than the purpose which they gave consent to the making of original fixation of or reproduction, or original fixation was made in accordance with section 68. So let's look at what 68 talks about. So 68 talks about exceptions to performance rights, where a performer consents to you including his performance in a visual or audiovisual copyrighted work. Now, it goes further to say that the provision of part 2 of this act shall apply with necessary modification. So what does part 2 state? Oh gosh. So part 2 of this act is talking about first ownership of copyright in a collective of assignment and licensing, compulsory license to produce and publish translation, compulsory license to reproduce and publish work for certain purposes, license for broadcasting organizations, definition for the purposes of compulsory license to publish and produce translation, to reproduce and publish works for certain purposes, and finally compulsory license for public interest. So I guess after this I'm going to be talking about the compulsory license, and then ownership transfer and license as stated under, oh sorry, that's part 3. Oh my gosh, sorry. Part 2 talks about general exceptions, which is the fair dealing principle, the 4-factor principle, acts for purpose of instruction or examination, recording of broadcast by educational establishment, restriction of reprographic copying by educational institution, special provision for archives, library, museum, galleries, special exception for blind, visually impaired, or otherwise print disabled persons, special exceptions in respect of sound recording of musical works, and that's about it. So let's go back to section 68 now. Yeah. So recall that section 68 talks about exception to a performance right. So it goes further to say that any performance or a fixation of a performance reproduction may be used without the consent required under section 63 if the purpose for doing that you demonstrate in good faith of a radio or television receiver or recording or playback equipment to clients by a dealer in those receiver or that equipment, reproduction or short extracts from an object of the performance right in reports or current events, kind of like fair dealing anyway. So for research, private study of an object of performance right kept in publicly accessible libraries, educational establishment, museums or archives,
on the premises of the set. So you have to do all of this within the premises of these institutions that are listed, the libraries and the museums and the archive. Then reproduction for the benefit of people with disability, which is directly related to the disability, and a non-commercial nature to the extent required by the disability, and making of an inferior recording of an object of performance right by broadcast organizations by means of their own facilities for their own broadcast, provided that that recording may be preserved for a period of not more than 30 days and must be erased after the use of for broadcasting. So it kind of gives you some sort of data protection requirements where you're required to retain data so far as you do that with the consent of the data subject within a timeline. And then talking about the recordings of an exceptional documentary character may be transferred to designated archive for preservation. So the fair dealing principle for performance is well detailed, and I would say again, kudos to the drafters, because it wasn't included in the previous act, and this kind of helps settles or deal with some issues that we've seen within the last couple of weeks. Then let's go back to rights of performance. Now you also have the right to distribute to the public by sale. So recall, let's take that again from the beginning. A performer has exclusive right to control how his performance is used, whether it's in a fixed or unfixed format, the reproduction of the fixation. Remember, fixation talking about tangible formats, which will include reproduction for the purpose of no more than other than the respect for which the performer gave consent to original fixation in accordance with section 68, which is the exceptions for, or the fair dealing exceptions for performance right. They also have the right to distribute to the public by sale or transfer ownership of its performance or copies that have not been subject to distribution authorized by the performer, broadcasting and communicating his work, whether on fixed performance, in the broadcast to the public itself, renting and lending to the public or public lending of a fixation or copies of the fixation of his performance, irrespective of the ownership of the copyright of the copy rented or lent, making available to the public of his fixed performance by wire or wireless means in a way that members of the public may access them from a place or time individually chosen by them. Then I've already listed what performance will include when I was talking to the actors and the rest. Then let's go to protected performance, which is under section 64, which talks about the right granted to the performer, just like the ones I listed, right to distribute, to broadcast, to rent and lend, to distribute, to control how his performance is being used and all of that. And the right granted to a performance that shall apply in respect of any performance if on the date of the performance at least one of the performers is a citizen or resident in Nigeria. The performance took place in Nigeria, was first fixated in Nigeria or done in Nigeria, or in a country who is signatory to a treaty or other international agreement which Nigeria is signatory to, such as the Rome Convention, which gives performers in audiovisual work such as films or videos, television, drama rights against unauthorized broadcast or recording of their performance. Moving on, where the question arises as to whether a country is part to, so just I think I mentioned that earlier on. So when someone is trying to query the whether a country is signatory or a member state of a treaty that Nigeria is part of, the Copyright Commission will issue a certification stating that this country is also a member state of the treaty that Nigeria belongs to. Now, presumption of consent, which is very important, because when it's dealing with IP, consent, permission, or authorization is something that you must not joke with. Without consent, you cannot do anything. Anything without that is an infringement. So, in the absence of an express agreement to the contrary, the performance consent to the broadcasting of his performance shall be deemed to include his consent to an authorized rebroadcasting of his performance, the fixation of his performance for broadcasting purpose, and the reproduction for broadcasting purpose of such. So, I mean, it's like, so when you give consent for someone to do something, not someone for, so you gave your consent that your performance should be broadcasted. Now, what the law is saying that other rights that you've now given that person is the right, you've authorized them to rebroadcast your performance. For your performance shall be only for broadcasting purpose, and the reproduction for broadcasting purpose. So they're not going to go outside the confines of that agreement, and I believe it's going to be for a term of duration. Then again, moral right for performance, love it for you guys. I mean, before it wasn't extended to performance, but it was kind of implied that performance also had moral right. So moral right for general, should I say general, I don't know now, so let me just say moral right for literary and artistic work or musical works will imply that they have the right to, preserve or make sure that no one distorts their creativity. So the same thing also applies for performance here. First right is that they have to be identified as the performer in connection with any use of their performance or the fixation, object or prevent any distortion, mutilation, or modification of their performance, or any other derogative action that would cause harm to their reputation. And also, it shall not be transmissible during their lifetime, but upon their death, that's the performer's death, it shall be transmissible by testimony disposition or by operation of law, and shall subsist for the duration of the performance rights. Let's look at collective performance, and where several performers as a group take part in the same performance, it shall suffice if the consent required under section 65. I talked about consent where your consent was expressly agreed, and you agree that it can be rebroadcasted and you can reproduce the broadcasting of your performance as well. So what am I talking about now? Yeah. So it says where the consent required under section 65 is given by any person in charge of the group, or any payment for the use of the performance may, unless otherwise stipulated, be made to such person and subject to any contract between them be divided. So if, for instance, now you're a band group and you have like point one, should I be saying that? Like, you have someone who is like your leader, he can make decisions on your behalf, he can also receive payment on your behalf, but outside the contract it will be divided equally amongst all of you because you are all collective performance. So I already talked about the exceptions, which is similar to the fair dealing principle. Now let's talk about transfer of performance rights in an audiovisual work. So the provision of section 30, what does section 30 state again? Let me get back to that. So section 30 focuses on assignment and license. So it says, for the purpose of chapter 4 of the Constitution, love it again. I mean, copyright shall be deemed to be a movable property and shall be transferable by way of an assignment, testimony disposition, or operation of law. An assignment or testimony disposition of copyright may be limited to only some of the acts which the owner of the copyright has the exclusive right to control, or to a part only of the period of the copyright, or to a specified country. So it kind of like gives you an idea of what should be also included in the assignment contract that will be signed between parties. I think this will mainly be used between CMOs, that's collective management organization, which I will talk about later, and copyright owners such as musicians and authors, and all the groups that are members of a collective management organization. An assignment of copyright or an exclusive license to do an act, the doing of which is controlled by God, shall have no effect unless it's in writing. Similar to the previous provision under section, I think it's 11, under section 11, where it said that an assignment or an exclusive license must be in writing, shall be in writing. A non-exclusive license to do an act which is controlled by copyright, may be written, oral, or inferred from conduct. I think that's pretty easy. An assignment or license granted by one copyright owner shall have effect if granted by his co-owners. So same thing, kind of like when we're talking about the collective performance. So here, that's under section 30 of where it says, any assignment or license granted by one copyright owner shall have effect as if granted by his own co-owner or subject to any agreement between them. Any fee received shall be divided equally amongst the co-owners. Then it goes further to say, for the purpose of these sections, persons shall be deemed to be co-owners if they share joint interest in the whole or part of a copyright, or have interest in a copyright in various works comprised in a production of two or more works. Sub 7 says, ownership of a material in which a work is embodied shall not confer ownership. Then a copyright owner who transfers ownership of his material in which the work is embodied shall not be deemed to have transferred his copyright. So even if someone transferred their copyright to you, they're not giving you the economic right or moral right to be recognized as the copyright owner. Sure get, or that you have or to have granted a license for the exploitation. No. Even if it was provided for in an agreement, an owner of the copyright who transfers the ownership of the material has not transferred his copyright. So take note, the fact that I signed an agreement with you doesn't mean I've transferred ownership of my intellectual property or copyrighted work. And it says further that, except as otherwise provided for an agreement, an owner of the copyright who transfers copyright or grants a license for the exploitation of the work shall not be deemed to have transferred ownership. Same thing. I think you just kind of narrow this down to NFTs, where people feel that if you buy a minted copy of an limited edition, you own the right to. No, you do not, man. I was going to use a swear word, but I'm not going to do that because I have listeners who are preteens. Yeah, so let's keep my podcast holy. But moving on, I think I've already explained that the intent says an assignment or license or testimony disposition. Now, when I mentioned testimony disposition, I meant either it was a deed of gift or it was included in a will. So whenever you hear that, know that that is what I am talking about. So it says, so sub 10 of 30 says, an assignment, license, or testimony disposition may be granted or made in respect of future work or an existing work in which a copyright does not subsist, provided it shall not be permitted to transfer the rights in all future works of an author. I think if you are a creative, especially my musicians and book authors, be very wary of this section. Should get. So you don't end up losing something that, So, okay, I think I misinterpreted that, but let's take that again. An assignment, you're giving someone permission to do this. A license, consent to do this. Put in a will, granting them copyright, giving them access to use your copyrighted work. That does not mean that they have the right to transfer your own rights now in all your works, all your future works, to some other person. They do not have the right to do that. A testimony disposition of a material on which a work is first written or recorded shall, in the absence of any indication to the contrary, be presumed to include any copyright or prospective copyright in the work which is vested in the disease. Love this. So basically, if your will, hold on. So remember I said testimony disposition could either be a deed of gift or will. Now, in an event where the work in question was first recorded or written, and there's no other indication that there's another work existing, that it is presumed. I hope I'm interpreting this right, but I would reach out to NCT to help me further explain. But I'm doing the best I can. That work created is considered to include copyright or any prospective copyright in the work which is vested in the deceased. So, for instance, let's use the Green who died now. He already had catalogs or portfolio of copyrighted work, musical works. So it, it's already assumed or presumed that the musical work he has includes a copyright or has prospective copyright in the musical work and sound recording, as the case may be. Always open to conversation, guys. So let's not be like we're fighting. If I did not explain 30 sub 11, please let me know, or just correct me, send me an email to ipseriesInfo@gmail.com. But let's wrap up section. That's the performance arts, the performance rights section, and then we'll be done. So duration for performance rights is for a period of 50 years commencing from the end of the year when the performance was first fixed. Then infringement. How do you know you've infringed a performance work? When you do or cause any person to do any act and not provided for under section 63. Remember, 63 talks about he went further to list what a performance is, the exclusive rights that a performer rather a performer has, where you go to broadcast a substantial part of a live performance. Davido held his timeless concert. So if you go ahead to broadcast a substantial part of his live performance, either by recording it, or the person has to do, where you did that without Davido's concert. I'm using Davido's one because I'm recording this particular one a day after his performance. But yeah, if you import for reasons other than for private use, if you import any performance work other than for private use, or the exceptions as listed for performance rights, you also be infringing. If you use a recording of a performance work for other than for domestic use or private use, you're infringing. Now, if in the course of your doing business, you end up selling or leasing for hire, distribute or display, sell a recording of a performance work, such as any Dirty December video without their consent, that's an infringement. Now, section 72 says an infringement of a right protected under 63 and 65 is actionable as a breach of statutory duty, and the person having the right shall be entitled to damages, injunctions, and account of profit or conversion. Now, where a person in the course of doing his business has in his possession, custody, or control an unauthorized recording of a performance, the person having the performance right or recording rights in relation to the performance shall be entitled to an order of court that the recording be forfeited and delivered up to him. I mean, this new act is really proactive, and let's see how NTC make sure that everyone is compliant to this provision. Now, let's look at criminal liability in respect of an infringement of performance. Now, anyone who, without the consent or authorization of a performer, does any act that I listed previously from section 729, you sell, you hired, you recorded, you broadcasted, you imported, you did everything that you're not supposed to do, and you're not a performer, unless you can prove to court that your conduct, that you did not know that your conduct was an infringement of the performance right, you have committed an offense and you're liable to conviction. Now, if it's for an individual, a fine of 100,000. Anyways, minimum sanction, you're entitled to at least 100,000 naira or imprisonment for a term of at least 1 year or both, and if you're a body corporate, to a fine of 2 million naira. Sweet, right? Yeah. Now, a court before which an offense under this section is tried may order that the recording or any other part be delivered to the person entitled to the performance right. Love it, 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 love it. So yeah, that's about it for performance right. Let's get into, should I talk about assignment? No. Should I talk about folklore? No. I think so. But yeah, I would touch a bit on folklore, anti-piracy, how you can claim copyright to your work, very important. And I'll just, make my closing. Shall we take a look at anti-piracy measures? Why do you have, or why do jurisdiction um you know draft anti-piracy strategies or measures? Basically to prevent illegal sharing of content, um use of copyrighted content, prevent the distribution of pirated copies, um, so that the copyright users are properly remunerated. You can also take actions against people that are repeated offenders. So kind of like ties it back to take down notices, the um, technological protection measures. Um, so let's look at what the law has to say. So the law provides that for anti-piracy measures, the Copyright Commission shall have the power, with the consent of the minister, to prescribe any design, label, mark, impression, or any anti-piracy device for use or in connection with any work in which copyright subsists. Any person who sells, rent, hires, or offers for sale, rentals, or hire any work in contravention of the prescription made under subsection 1 commits an offence and is liable to a fine of 500,000, again minimum sanction, or an imprisonment for a term of 3 years or both. Any person who, without the permission of the commission, imports into Nigeria or has in his possession any machine, instrument, or anything that can be used for the production of anti-piracy devices, commits an offence liable to a fine of 1 million naira or an imprisonment for a term of at least 5 years. Now, if any person who, without the permission of the commission, so for anti-piracy works, I would say the Copyright Commission is like spearheading or representing the copyright owners, making sure that there's no room for people to want to leak, say, a movie such as Gangos Lagos that just came out in 24 hours. Were already copies out there. Original, it helps you also prevent or be able to track the original source of leakage or unauthorized use, making copyrighted work available online, you know. So basically the commission helps restrict these anti-piracy measures are put in place to restrict copyright infringement, receives easy access of content, especially in line of we being in the streaming era. um you know so going further, it says any person who, without permission of the commission, is in possession of any anti-piracy device prescribed under the section, and for no reason has no reason to believe that what he has is not an anti-piracy work or device, is liable to a fine of 100,000 or imprisonment of at least a term of 1 year or both. The commission shall have the power, the consent of the minister, to make regulations specifying condition, whatever. So anti-piracy measures to take legal actions against copyright infringement to help reduce and eliminate illegal sharing of copyrighted content. Would a cease and desist letter help in this instance? I guess so, you can say so. It also goes to show that the creative content is valid when you issue a cease and desist letter. So looking forward to the regulation that the commission will make with regards to anti-piracy measures. And let's talk about the need to, or the duty to, keep records. And it says any person who, so if you're a publisher, printer, producer, manufacturer, aggregator of works in which copyright subsists, you are required to keep a record of all your works you've come in contact with in the course of doing business, such as the name of the author, title of the work, date of use or production, quantity of the work used or produced, especially where you now see that there are pirated copies of book being sold or reproduced or distributed. When you have those records, you're able to track and know who went behind it to go and, print out or publish more copies without your consent, maybe within your workplace or not, or whatever. Any other information that may be required by the commission, and any person who fails to keep record under this section, or makes a causes to be made, or does impute any false entry, or produces or tenders, or causes to be produced or tendered as evidence an entry that is known to be false, commits an offence liable to a fine of 100,000 imprisonment for a term of at least 1 year or both. And then sub 3 says any copyright owner or any person having an interest in a work shall on written demand be furnished with information relating to the work. So you can demand to get your record, just to follow up from your own side. Now let's take a look at the compulsory license. So next up on our review is compulsory license to produce and publish translation, compulsory license to publish, reproduce works for certain purposes. I think this is a welcome development in the Act. And the Act went ahead to say that it's only qualified persons, people who they feel want to use this for, you want to teach, scholarship purpose, research, you apply for a license to the commission, that's the Copyright Commission, so that you can be able to produce and publish a translation of a literary work. And at the end, what you get is a non-exclusive license to produce and publish. You already know that non-exclusive means it's not only one person that has the that was granted the right to do certain exclusive rights that are granted to a copyright owner. You can also pay the owner of the copyright work some royalties for the copies of the translation of the work that you produce, and then the commission will also calculate the rate for which the royalty will go. That license does not extend to you exporting copies of it, and each copy of that translation must contain a notice that it is only available for distribution in Nigeria. It will not also apply to export by government or any of the agencies of such copies. And the license in question granted shall not so it says a license shall not be granted by a commission under this section until the expiration of 1 year from the date of first publication of the translation that you did, 3 years from the date of first publication of the work where application for a license is for translation into English. And then the license will not also be granted if the Copyright Commission is not satisfied that the translation into the language that you've published, or if into the language that has been published or reproduced with, if you've gotten consent of the copyright owner to actually translate. So you've gotten the right of translation from the copyright owner, and if you have proved to the commission that you had been denied permission by the owner to actually produce and publish your translation after you've done your due diligence, you will not get a license as well. Where you do your due diligence and you're still unable to find the owner of the copyright, and you had already sent permission to the publisher whose name appeared on the work not less than 2 months before applying for the license, different things that have been included. I think one thing that I want to point to or direct our attention to is the fact where it says a period of 6 months has elapsed from the date of sending the request, and have not been published by the owner of the copyright in the work or any person authorized by him within a period of 9 months. Then you also include the name of the author, the title of the particular edition that you want to translate, where the work is composed mainly of illustration, the provision of section 6 are complied with, the author has not withdrawn copies of the work from circulation. The commission may also withdraw that license um, if the grant has ceased to exist as well. So if I would want to interpret this to mean that the copyright owner has either terminated his license or whatever. Then you also have compulsory license to reproduce and publish for a certain purpose. So this one is more specific. It has to be done with a purpose in mind. For instance, if copies of the edition was not made available in Nigeria or has not been put in sale in Nigeria for a period of 6 months um, by the owner of the right of reproduction. Remember that each copyright work has exclusive rights that are accorded to a copyright author, and same reasons why a license will not be granted to you by the commission. And then they went under, so subsection 732 says the provision of this section shall also apply to reproduction and publication or translation into languages spoken in Nigeria of any text incorporated in audio-visual fixation prepared and published solely for the purpose of systematic instructional activity. So I would say the Copyright Act is a bit clear as to what um, intending users should do when it comes to copyright work. The relevant period in relation to any work means a period of 7 years from the date of first publication of a work in respect of a fiction, poetry, drama, music, or art, and 3 years from the first date of the first publication of a work in respect of natural science, physical science, mathematics, or technology. Then there's the compulsory license for public interest. No definition for what public interest would be, but basically what the art is saying is that the commission may authorize someone to use the copyrighted work for the purpose of rectifying the abuse of a dominant market position, or again promote public interest. So you go ahead to apply for a license which is non-exclusive and you cannot assign it. It's only to be used in Nigerian market, and the copyright owner will also receive his royalties, taking into account the economic value of the work authorized to be used. Similarly, again, rights to withdraw consent were given. Then let's talk about licenses for broadcasting organization under Section 33. So broadcasting organizations are required to apply to the Copyright Commission for a license to produce, publish for non-commercial purpose translation of a work, as stated under 31, which talks about compulsory license to produce and publish translations. They are also required to get a license for any text that has been incorporated in an audiovisual work prepared or published for the sole purposes of instructional activities and purpose of teaching, result of specialized technical or scientific research to the expert in a particular field. So that's about it for compulsory license. I think I'll just talk about the role of CMOs. If you've been following my shorts series, I have also talked about that, but then I'll just touch on it in this podcast as well. So if you are a creative entrepreneur, you work in a creative space, you interact with creatives, or you represent a creative, you render services to them, have you ever considered telling them to interact with the collective management organizations who can act on their behalf, who also have their best interest at heart? So who are the CMOs? They are sometimes considered to be middlemen who have been set up for the purpose of not making profit first, representing the copyright owners, inclusive of copyright owners and related right owners, help them negotiate and license and grant license to people that want to use their content or their works, collect and distribute royalties on their behalves, and in order for them to do this, they need to also get a license from the Copyright Commission. So, what are the types of CMOs that we have in Nigeria? First, I would like to make mention of the Audiovisual Rights Society of Nigeria, which takes care of those in the movie industry. So if you've ever gotten a letter asking you to pay some sort of royalties because you have been publishing or communicating movies or showing movies within your facilities, and these are the people in charge of it. So make sure that at the beginning of every year you reach out to them to get the required license for you to actually publish or communicate those movies to your consumers or customers. Then you have the musical copyright Society of Nigeria, which is set to be the first CMO for the music industry as far back as 1989. Then there's COSON, but prior to this act, COSON's license was terminated. COSON represents songwriters, composers, publishers, performers, record labels, while MCSN represents musical and sound recording owners. So you kind of see like their roles are interplayed. So maybe they can at least merge. I don't know, guys, but Then you have Repro NIG. That's the reproduction rights organization who represents literary and artistic fields. They manage reproduction rights. So you have right to reproduce. All of the copyright works have the right to reproduce. They also grant license and distribute royalties to members who include the Association of Nigerian Author, ANA. Then you have the Academic and Non-Fiction Authors Association of Nigeria, National Association for Translators. So we just recently talked about compulsory license to reproduce and publish translation. So these are the people that. So the sector that you'll be interfacing with is the Repro NIG. They have Newspaper Proprietor Association, Nigerian Publishers Association, Photographers Association of Nigeria, and Society of Nigerian Artists. Basically, their role is concerned with reproduction right, like I stated, which includes secondary use of works through photocopying, scanning, electronic storage of printed materials, fiction and non-fiction, books, journal, periodics, magazines, newspapers, works of visual art, photographs, camp programs. You also require prior authorization, which includes any use in educational institution and research institutes, and they also issue licenses to photocopy shops, corporations, delivery services, education research centers, and they're also known to be affiliated with the International Federation of Reproduction Rights Organization, that is the IFRRO. The one section that crossed that I saw and I thought might be related to the reprong CMO is section 23. We basically talks about restriction on reprographic copying by educational institution, which states that where the copying of passages from published literary or musical works for educational institutions is to be used for the purpose of instruction, it shall not infringe now. And then the requirement is that you cannot do more than 5%. You cannot copy more than 5%, or if it's done on behalf of or within the space 3 months for the educational institution, and in the event where there's a licensing agreement, it shall not apply. If the license terms restricts you copying certain parts of the literary or musical works or whatever work in question, you must do well to abide by it. Then exceptions found in section 21, which is that copyright in literary artistic work shall not be infringed if it's being copied in the course of instruction. So I'm going to teach students, or I'm giving a webinar or something. As long as the copying is done by a person giving or receiving the instruction, and is not by means of a reprographic process, then copyright in sound recording, audiovisual broadcast, or cable program cannot be infringed if it's being copied in the course of instruction at a non-profit educational institution, in the course of preparing for your instruction, and that copying is done or used by the instruction for the person giving or being. Can anyone just wake up today and say, "Oh, I want to create a CMO in Nigeria"? No, you have to first of all apply to the. Okay, first you have to be incorporated as a company limited by guarantee under section 20, sub 1 of the corporate, sorry, company and allied matters act 2020, which is usually formed for the promotion of commerce, art, science, um religion, charity, or any other similar objectives. So people that are critics who are coming together always have a similar objective of getting someone to act on their behalf, to negotiate licenses for them, to you know, collect royalties on their behalf as well. So it could be a group of persons or owners of copyright works basically. Yeah. So other than that, they apply for a license from the Nigerian Copyright Commission, who is basically a regulatory and enforcement agency and has the power to grant them that license. The objective will include that they have to grant license, collect royalties on behalf of the copyright owners, and represent substantial amount of copyright owners in any category, and must comply with the terms and conditions presented by the Nigerian Copyright Commission. So once they assent or agree to that, then they are good to go. And anyone who goes against this, if you're an individual, you're liable to a fine of at least 1 million or imprisonment for a term of 5 years, or if a body corporate, a fine of at least 5 million naira. The commission, I've already stated the roles of the commission, but let's talk about the role of a CMO. What are they required to do? So whether or not you are a member of a CMO, subsection 9 of 88 provides that a CMO may issue licenses permitting the use of works of owners of copyright who are not members, provided that such works are in the same category as work for which the license that NCC gave to them is. The owner of the copyright in such work are not otherwise represented by any other CMO. There's more than one CMO approved. There's not more than one CMO approved to operate in that particular category. And the owners of the copyright in such work have not written notice to the CMO to opt out of their collective management of their rights, and the CMO does not discriminate against such owners in terms of tariff from the use of their work and payment of royalties to such owners. And as just an aside, I want us to note things that are not eligible for copyright protection. They include that. So someone cannot say he owns an idea or procedure or process or format, system, method of operation, concept, principle, discovery, data. You cannot own official text of a legislative or administrative nature or any translation of any sort. You cannot own a state symbol or insignia, which includes flags, coat of arms, anthem, banknote design. I think we had a case, but that was copyright related anyway. The Naira case. I don't know how many of you remember it, but just to include that. And then I'm going to talk about anonymous work. I did see that. I'm trying to get to it. Just hold on, guys. So when we talked about, or when we are talking about comment duration of copyrights. So for instance, literary work, musical, artistic works other than photographs last for 70 years after the end of the year in which the author dies. Um, while works that are while works made under the direction or control of a government or an agency of government or any prescribed international body last for 50 years after the end of the year in which the work was first made available to the public, or 50 years after the work was created if it wasn't made available to the public within that time. While audiovisual photographs, 50 years after the end of the year in which the work was first made available to the public with the consent of the author. So you see how the Copyright Act stresses on consent, getting license, getting permission. So I want to see changes going forward. Sound recording 50 years after the end of the year in which recording was first made available to the public with the consent of the author, or 50 years after the work was created if not made available to the public within that time. Broadcast 50 years after the end of the year in which the first broadcast took place. And then sub 2 of section 19 talks about copyright in anonymous or pseudonymous literary, musical, or artistic work. Now, when I saw this particular provision, I was really excited for copyright owners because this is one of the new introductions that I think would give people within this category some sort of protection. So if you create literary work, musical work, or artistic works as an anonymous person or pseudonymous person, you enjoy 70 years after the year in which the work was first made available to the public with your consent, or 70 years after if you did not make it available to the public within that time. That when you become known, the duration of the copyright shall be in accordance with all the other previous ones that I mentioned. So basically, this category of persons are people that don't want their identity to be revealed, while pseudonymous. Okay, so your identity will not be released, and then you also use pen names to identify yourself as the author of the work in question, or nickname as the case may be. International framework to take note of is the Berne Convention for the Protection of Literary and Artistic Works. Specifically, Article 7.3 of the Berne Convention states that in the case of anonymous or pseudonymous works, the term of protection granted by the convention shall expire at 50 years. I think Nigerian Copyright Act is a bit generous, granting 70 years, whether with your consent or without your consent. But the Berne Convention says 50 years after the work has been lawfully made available to the public. However, when the pseudonym, oh God, apologies guys, adopted by the author leaves no doubt as to his identity, the term of protection shall be provided in paragraph 1, that is the life of the author, and 50 years after his death, pseudonymy. However, in most countries, the author subsequently discloses his identity after publication, and then the normal term starts to read. Now, countries that have incorporated these laws are the United States, the United Kingdom grants 70 years if the author is unknown. India as well, so this is a welcome development. And then in the event of a joint authorship work, reference to the death of the author shall be to the author who dies last. So can a CMO represent people with anonymous or pseudo work? Yes, they can. They are all considered to be copyright holders. So the role of a CMO basically will be to reduce transaction costs where the eligible work are exploited. Eligible work will include copyright and related rights, and then it gives users access to the work legally. They basically act as admin head for copyright owners. They possess a bundle of multi-territorial licenses. I think the license is also restricted because when the artists assign their rights to them to represent them. It's not everything that they are permitted. It's not everything that they are permitted to do. Then, hmm, then they can also sue on behalf of the copyright owner where their work was used without their consent, permission, authorization. They can also monitor the use of the copyright works. I think there's a recent case now. Can't remember it, but it came out this year where a CMO sued an airline. So it's not a Nigerian case, by the way. Sued an airline company for publishing certain. I think it was for movies, not for songs. I think I'm missing, but yeah, they sued on behalf of copyright owners, and the court stated that that did not fall under their jurisdiction as they did not infringe on anybody's right, you know. So the question now is, are airlines supposed to, what kind of licenses do airline operators get, and where does the CMO right begins and end? And the role of the copyright owner is to assign um an exclusive license to the CMO to help them monetize their bundle of exclusive or substantial bundle of exclusive rights. They end up relying on the CMO to help them monitor the use of their work. Now, has this new act cured certain issues that CMO experiences in Nigeria? Not necessarily, but I think they're in the right step or right direction. So waiting for the collective management organization regulations that the um, copyright commission would work on. So yeah. So I guess for me, one thing that I sort of looked forward to was seeing if there was like a termination or reversion of copyright as is provided under the US law, where after 35 years, if you had granted someone license to use your work, you can always terminate. But then there's room for improvement. Protection of hyperlinks. I'm also happy that we now have like a new level of moral rights where copyright owner has the right to give the work a title or leave it or dedicate it to someone, as the case may be. So, but yeah, that's it from me. That's it from me, anyways. So, in wrapping up, my assessment would be that this new act, I would say, is a good one. Maybe in future the commission can create guidelines to deal with copyright issues in the digital age, such as originality of works created as a result of AI, tech, deal with issues as to are works created by non-human original, do they meet the basic requirements of putting in effort, being in a fixed medium, and any other emerging frontiers that we may come across. Maybe a proper definition of what is originality, proper definition for infringement to include alleged who an alleged infringer is or threat of infringement, and maybe use of copyright notices, statements, disclaimers for fair dealing proceedings. But yeah, kudos to them. I know this is going to be I think this is the longest I've ever done, but thank you to everyone who is currently listening to me. So to wrap up again, thank you everyone for listening to me. And I'll say see you in the next episode, and look out for conversations on the new acts just to get better clarity on the provisions. And yeah, see you in the next episode. Bye guys.